Good evening. This is John Milburn for Laws 12062 Alternative Dispute Resolution. We're into week 3. Let me start with this material. Role playing. My name is John Milburn. I'm appointed as your mediator today. Thank you for appointing me. I appreciate that you have taken the time and trouble to attend, and I welcome your attendance. I welcome your ideas, and I encourage you to engage in open discussions today. I am a lawyer, but I'm not here to give legal advice, and I just want to confirm that I've had no previous contact with either of you. I have allowed 3 hours for today's mediation session. Do either of you have time constraints? My preference is to engage in the mediation process using first names. I hope that's acceptable to you. Please call me John. Now, I mentioned earlier that I'm a lawyer, but I'm not here in that capacity. What I meant is that I'm not here to provide advice and I'm not here to make a decision. But what I am here to do is to assist you in identifying issues of concern, to assist you in attempting to resolve the dispute that you have. And it's important that you understand that I will encourage you to take ownership of this dispute, to make it your own. What you don't want to do, I think, is allow the dispute that you have be taken from you. And if the matter goes to litigation and is decided by a court or tribunal, then that decision is to be taken away from you, and you lose the benefit of trying to make a decision that works for you. Now, in terms of process, I'll hear from both of you in turn. Without interruption, if I may, and thank you for your cooperation in that regard. If you have questions that arise or comments you wish to make while the other party is speaking, there's a paper and pen in front of you. Please feel free to make some notes. Now, once I've heard from both of you in turn, and just 5 or 10 minutes, if I may, for each of you, with your help, we will set an agenda and then we'll engage in discussions together. Most likely, following the joint session where we're engaging in these discussions together, I will engage in private sessions with each of you in turn. Now, if I do, I will try to keep the time that I spend with you roughly equal, but what I can assure you of is that what you discuss with me will remain confidential between us. I'm not going to repeat anything that you say to the other side, at least certainly not without your permission. And even then, once we complete the joint session process, the private sessions, and we go back into joint session, I will encourage you to discuss these things from your own perspective rather than through me. What we hope to do when we rejoin in the joint session is to work towards a resolution of the problem. And if we do resolve the problem today, I'll certainly assist you in drawing an agreement, and my expectation is that we will sign the agreement today. So it's important that I have your commitment that you have authority to make the decisions and sign an agreement today if we reach that stage. Is that the case? Thank you. Today's procedure is without prejudice. What that means is that statements that you might make in this protected forum remain, if you like, cocooned. If you make a settlement offer, if you compromise, if you come up with an idea that might resolve the issue, then rest assured that those statements, those concessions, those ideas that you promote will remain confidential in this process. Can't be used in later court or tribunal proceedings, certainly can't be used against you. I encourage you to discuss openly the concerns that you've got. I also encourage you to listen very carefully while the other party is raising those concerns. And what we might be able to do is come up with some novel solutions. If you don't come to an agreement today, then the decision will be imposed on you, and a tribunal or court is going to make a decision about someone's credibility. Someone is going to suffer a loss, and indeed it's potential that both of you will suffer a loss. So during the course of the mediation session, I will ask you to consider the best alternative to a negotiated agreement, the worst alternative to a negotiated agreement, and think about the cost, the time, and the emotions associated with proceeding beyond today. Look, in reality, it's my experience in mediations that where parties do come to an agreement, it's likely that both will leave just a little disappointed. And if that happens to both of you, then arguably any settlement that you might reach today could be just about right. The process remains confidential as far as I'm concerned as well. So anything that you say will remain confidential. I'm not going to release my notes or information. In fact, I'll try to keep brief notes just for my own information, and I will destroy those notes at the conclusion of the session. There are some exceptions. One of them is, for example, my duty to disclose if threats are made, if there are genuine concerns about safety. I'm sure you understand that. Now, do either of you have any questions before we commence the process? All right, thank you. Let's begin. James, this is your application. I'd like to hear from you first in terms of your opening statement. And Mary, if you'd be kind enough to remain silent, make notes, and remember, I will be asking you to join with me in creating an agenda. Thank you, James. All right, so that's the end of the role play. That's not the only way to do things. It's just the way that I tend to do things. And the way in which I commence a mediation or conciliation does vary depending on the nature of the dispute and the nature of the parties that I'm dealing with. Quite often I'll have sessions before we begin the mediation proper. It's very common for me to engage in discussions with the parties privately before we even begin the mediation proper, to explain the process, to get some idea of background, to read material, and perhaps even consider submissions. So the mediation opening that I provided there in sample is really an example of where I'm meeting with the parties at the mediation session for the first time with very limited background information and very limited contact with the parties before we begin the session. So that's the sort of opening that might suit, even in a family law matter or a neighbourhood dispute or a relatively simple matter. If it was a more complex commercial matter, particularly with a number of parties, I'd probably do a lot more preparation before we started that. Now, again, what I've just said is not something that you have to repeat word by word in the assessment piece. You won't necessarily get any prizes for being able to repeat that word by word. In fact, I'd prefer you came up with your own style, your own flow, your own information. Everything works a bit differently for others. And you'll note that what I did tonight was a little different to what Jackie did. Thank you, Jackie, last week. And that's not to say that mine's any better at all. Jackie's was excellent. So just slightly different, and you may come up with your own. Now, someone mentioned that they looked at a very good YouTube clip in relation to a family law dispute during the week, and I may have put that on Ucrew or on Moodle, but there are some very good YouTube clips of mediators and conciliators providing opening statements and going through the process. So all of this, of course, relates to the first assessment. Now, are there any questions, comments about what I just did or generally about the opening statement? Now, B, you said you can read the script for free. I found it useful for witness for the prosecution. Oh, okay, so that's to do with 12 Angry Men. Thank you. Any questions about the opening statement, process for the mediation or conciliation? All good? Why do you think? Yes, Nicholas?
I did notice, John, in that statement, you made a couple of statements that basically may be seen as a little bit aggressive, but I can see that they're done deliberately. They're done to inform the party that if they don't go and make X, Y, Z happen themselves, then that responsibility will be taken away. So you sort of you've blended through some of those negotiation techniques, but I can see why now, hearing your delivery.
Okay, thank you, Nicholas. And certainly the opening, I think, is an opportunity to try to engage with the parties and form a connection, but at the same time maintain an assurance for the parties that you are in control and you're experienced so that they understand that you will be providing them with some guidance throughout the process. Now, of course, the extent of guidance depends on the nature of the mediation and the contract terms for the mediation. In its very pure form, which is, say, for example, the style which is used through the dispute resolution centres in Queensland, which are managed through the Magistrates Court, the mediators have a brief where they don't provide options, they provide very little involvement in the process, and they really do, in a pure way, allow the parties to come up with their own solutions. My style, generally, if I'm allowed to do it, as a result of my brief or my contract with the parties, is to be more interventionist, and I think most barristers, most lawyers like to do that because we can't help but take control sometimes. But we've got to fight that urge and not take too much control, but be in control of the process. So thank you, Nicholas. Any other thoughts? Jackie said, yes,
I
B.
think it is important because I'm sure that there's one party one party may try to bully or browbeat the other party, and it's important that you stop or prevent that kind of thing from happening.
Yes, that's a good point. And I think it's also important to avoid, if you can, going into shuttle mediation mode too quickly if you perceive that there is bullying or the risk of power imbalance. So as a mediator, your role is to try and provide some degree of protection, some degree of buffer, and keep it as a level playing field, but still allow the parties to retain ownership and engage directly with each other. So there is a balancing act. Sometimes you can't do it. Sometimes it is definitely best to go into shuttle mode. All right, so thank you, B. Now, Jackie said, reality checking, what may happen if not resolved? Yes, so in the opening, I did throw in a little bit of reality checking in terms of just bear in mind this is your dispute, but if we don't resolve it, think about what's going to happen. Yep, that's a good point. All right, so that's just a sample that you might want to use. I think maybe make some notes, and you've probably already done that now. So in just speaking of the first assessment, I'm getting some ongoing information from people about the groupings. I'll just share the screen for a moment to give you an idea of what groupings I think we have. So you should be looking at a Word document. It's familiar, hopefully, because that's what I put in UCrew and what I put on the landing page for Moodle. You'll see there that according to my records, there are still some groups that I think have been put together, but I haven't received an email to say, yes, we are definitely a group. So there's 1, 2, 3 in that category. There's still a vacancy there with Simon and Marcus. So someone watching this live or on a recorded session, if you're looking for a group, there's one right there. Please let us know. Contact your fellow students. If you've formed groups beyond what you see there, please let me know and I'll update my records. So those records are a few days late, but I've been checking UCrew and I've been checking emails. I can't see any updates to that. All right. Hopefully now you've got your groups. You've made some arrangements. You've got on top of the technical side of things. Just on that point, obviously Nicholas McIntosh's material is excellent. You're very fortunate to have Nicholas as part of this cohort. Those of you that have worked with Nicholas in the past will know that he's always very keen to assist and willing to assist parties in terms of, and students in terms of IT. Hope I'm not putting you in the hot seat too much there, Nicholas.
No, it's all good, John. As always, I'll help out anyone I can, when and where I can, as long as I have the time to do so, of course.
All right. Thank you very much, of course. Yes. All right. So hopefully you've been through Moodle, you've looked at the assessment pieces, you've made diary notes of when you have to have your assessments done. You should be booking in with your fellow students as to when you're likely to do your recordings. And in the meantime, you should certainly have your script now for your opening. You should have a map of how you see your mediation or conciliation operating. You should have at least dot points of the issues in dispute and the factual scenario, and discussing that with your teammates. All right, are there any questions now about the marking rubric for the first assessment, the groupings, IT assistance, some of the common mistakes that we might expect? Monique?
Yeah. Thanks, John. I just wanted to double check with the the expectations for the assessment. So we're doing like a short format mediation. So it's not necessary that we get to an agreement stage. Is that right?
Absolutely not.
Okay, cool. Just as long as you can see that we've done that opening statement, we've covered all those, talking about private sessions and agenda setting and everything, then if we don't actually reach any agreement, then that's okay.
That's okay. And if you don't reach the stage of having private sessions, that's okay as well. Okay. So just let it flow reasonably naturally and don't force the issue or, make it settle. No extra marks for that. Thank you, Monique.
Sorry, so when we get to say 20, 25 minutes, we sort of make a statement that we're going to bring the session to a close now and then just turn off the recording. Is that what?
Yeah, okay? Something along those lines. Yeah, okay. Around that. Was it 20 or 25 minutes? Was it? So around that time. If you need to go a little longer, that's okay, but don't go too much longer. And you can wrap it up in a sense of, well, we allowed 25 minutes for today's session. We've made good headway. We've identified the agenda. Let's reconvene on a date that's suitable. Just something to wrap it up if you like.
Great, thank you.
Okay, thank you. All good? All right. So, communication skills. This, and I'll just say, with the assessment in the past, when I've done this, those of you that may have performed extremely well previously, academically, may not perform as well when it comes to this exercise. Conversely, those of you that have not performed so well academically may surprise yourself and you may do really well. It's part of the nature of this exercise that it is a practical exercise. It's one where people need to be on their feet, thinking, speaking as clearly as you can. Being light on your feet is what Judge Kingham would often tell us at QCAT, and drawing on your acting skills and your degree of preparation. So it's not so much an academic exercise. This is very much a practical exercise. So communication skills are very important. So as you're preparing for your mediation session, I'd like you to think about what are your strengths and what are your weaknesses in terms of academic or communication skills rather, and what knowledge do you need to acquire in order to improve your skills academically and in terms of general communication. Now, you might say, well, it sounds like it's all off the cuff. No, far from it. There's a lot of preparation that you can and should do for the first assessment. One of the best ways is to have some guideposts in mind and then either consciously or subconsciously start to practice these things. Let's talk about reframing. It's a common technique used in mediations, and it's something that you can practice as you just go through your ordinary day. So can anyone tell me about reframing? What is it? And why do we do it?
I think reframing is when, after someone has made a statement, particularly it's a very inflammatory statement saying that he was lazy, he's always out to get me, he keeps doing it again. So you sort of try to take the emotion out of the statement, restate it, but in more neutral terms, just sticking to the facts and not saying having to assume that the motive behind what's happened.
So the relationship is important to you, but there are certain aspects of the relationship that aren't working, and you'd like to discuss these matters with your partner. That type of reframing, yeah, along those lines. So exactly right. So what you're doing is you're taking the material that is toxic, for want of a better term, extracting the factual material and reframing it in a positive but neutral sense, which is forward-looking rather than historical. Now, the trick is to be able to do that on the run, and you need to practice those skills. So, watch a TV show where the parties are horrible, to each other or whatever. I used to say, watch a Seinfeld episode. There's so many things where you can hear a sentence and say, oh, let's reframe, just pause it. I know how to reframe that. I know how I could turn that around. I mean, I love Seinfeld shows, so that's not a criticism at all. But whatever it is, just you need to practice on that. Another thing is that when you reframe, you're usually trying to maintain eye contact. You're trying to engage in the party in a connection. And what you're doing is you're showing the party that you're listening very carefully. So you're demonstrating your active listening skills. When you're reframing, you're probably trying to focus the party's attention on you rather than on the other side, because you run the risk of allowing the unreframed statements directed to the other side to escalate, where the other side will bark back as a response, and you might have a walkout at worst case scenario. So whilst as a mediator or conciliator, you do want to engage or encourage the parties to engage in discussions directly with each other, maintaining eye contact, sometimes you have to ease into that once you've been through a few things. And reframing is something that you usually need to employ at the earlier stages of a mediation, but it may be necessary throughout. So what you're trying to do is strip the emotion and express matters objectively in a positive frame. Try to take out parties' positions and emotions and try to identify the true issues of concern. And hopefully they're issues of concern to both parties. Now, Nicholas, did you want to just raise the issues that you've put on?
Oh, that was just my definition, because we've had to keep that diary every week, and reframing was one of the terms we came up with in week 2, and that was just my expression of the definition of what reframing is. Speaking of which, that other video you got us to watch, William Ury, the negotiator, he does a speech about reframing where he talks about the 3 gentlemen that are left 17 camels. Now, I don't know if anybody's watched that video yet, but I highly recommend you watch it, because when you get the understanding of these 3 guys are in dispute over 17 camels. They're left 17 camels, and they're told the first brother gets half, the second brother gets a third, and the last brother gets 1/9. Now, they tried as hard as they could to work that out, and they couldn't come up with the answer. And you really need to think about it. And then they run off to a dispute resolution practitioner that says, I really don't know if I can help you much, but here's the suggestion: take my camel. And that's the answer, because they couldn't divide 17 camels, but when they got the extra one, the 18th, then what is it? Half of 18 is 9. Or is it? Is that right? Yeah, or two-thirds or something. It ends up being 9, 6, and 2. And so if you add 9, 6, and 2 together, it comes to 17. But you can't do that without the negotiator's 18th camel. And I thought that was a really interesting way to look at things, because the negotiator had to be there to close the argument off for the brothers. It was a really unique way of doing things.
No, that's great. And there's a lot of very good material out there. So thank you, Nicholas. And if you do come across some material that you find useful, please share it in your crew and let us know about it in Zoom sessions. So thank you, Nicholas. I appreciate that. Okay, so what you're trying to do in reframing is to build this rapport, to have the parties consider the issues rather than their positions, and try to assist them in retaining ownership of the real dispute rather than necessarily, the nonsense that might go with it. Not that you're going to be saying to the parties it's nonsense, and I'm saying that more from an objective perspective. From the parties, it's very real, but you need to provide them with that acknowledgement, that support, if you like, and that opportunity to make a connection with each other. At the same time, you're remaining impartial and you're taking control of the room and the process. All right, it does provide an opportunity for the parties to actually settle the process, because unless you get to the stage of identifying the issues, the real issues, you really don't have a realistic opportunity to encourage the parties or to help the parties to come to a settlement. And it also provides an opportunity for the parties to look at each other's dispute from the other's perspective. So in your textbook, there's an example at page 31, and in that the reframed exercise is, so you need access to the photocopier to effectively perform your job. You know, that's what you're trying to get to the key issues. Okay, open and closed questions. Can we have someone give an idea of the difference and when you would use, if you would use, open and or closed questions while you're performing your mediation or conciliation? So what's an open question?
Tell me why you're here today. It may not be how I'd state it in the mediation, but something along those lines that just doesn't have a defined response.
Yes. So thank you, Monique. So it's an opportunity to elicit information. Exactly. Jackie came in just at the same moment I said it. It's an opportunity for you to help set the agenda with the permission of the parties, and ultimately an opportunity to generate options. When you're listening to the responses to open questions, I want you to train yourself to zero in on an important word or a sentence or a phrase. You may not use that immediately, but you might keep it down the track. So someone, you say, why are you here today? You go through, someone will respond, and during the course of that response, there might be a word that you think can be useful down the track to help the parties to resolve the issue, whatever that might be. The word might be respect, and you just hear this word in amongst a lot of material, and you think, okay, so respect is an issue, let's just jot that down and see if we can work around that. It may be that that word becomes one of the agenda items. As mentioned, I think last week, I tend to favour 3 to 5 agenda items. How many do you work on a particular number of agenda items, Jackie, or do you leave it open-ended?
Sorry, I just had problems unmuting again.
You're right.
Look, I suppose it's kind of different because it's just unfair dismissal, so we're probably not into setting agendas as much because they fill out application forms before they come.
Yep.
So it tends to be more, so there is the opening session where we do listen to concerns, etc., and positions, but then it becomes more about resolution. What
Yes.
are they looking for to resolve the matter?
That's right. And I guess in a way it's almost a preset agenda, isn't it?
Pretty much, yeah.
Yep. Okay. No, I understand. All right. So, and you don't have to have 3 to 5. So that's why I'm really saying there's a wide range here. These are just general things that you need to consider. So do you think that ever an opportunity, do you think a mediator should ever ask closed questions? Now, I guess we could say open questions, we tend to ask them at the start, information gathering. Closed questions, what do you think, B?
Yes, because if you want to verify facts or if you want to confirm something.
Absolutely. Those of you that have done evidence and proof with me or other unit coordinators in the past will be aware of the use of open and closed questions in examination in chief and cross-examination respectively. But in the context of mediation, you'll bounce between the two. There's no rule that says you must only use open questions, you must only use closed questions. I think it's an appropriate thing to use a combination. And closed questions are a great way of confirming something, particularly if it's relatively positive, so that you've then got a recommitment, a restatement of something that's positive. So use both. And Jackie says, yes, to get confirmation. So thank you. What about silence? you know, and the tempo of the mediation session. Do you think it's good? Let's go with tempo to start with. Do you think the mediation or conciliation should run at a particular speed? And should that speed be consistent throughout?
I think maybe the parties should have a bit of a role in that, because sometimes they might need to think something through a bit deeper, or it might be a really easy response, or especially when considering options.
I think I like that, and I like the way that you said let the parties be involved in that process and feed off the parties. That's excellent. Thank you, Monique. And I think you're right, particularly when it comes to that end stage when we're thinking about options. In my experience, the mediation or conciliation session will just slow, the tempo will slow considerably, because you're allowing the parties to now come up with their own agreement. That's not the time where you want to force them. You want to keep it moving, but at a slower pace. I tend to think that at the start of a mediation session, it can go from brisk to frenetic, depending on how the parties are operating. Frenetic, it needs some special work from you as the mediator or conciliator. Sometimes, in terms of tempo, the parties will be at each other right at the start. Like it's round one and they both come out firing punches, so to speak. I haven't had one actually literally punches, but they're both ready to go. They're just fired up. So your job is to try and keep it balanced. Thank you for that word, Amanda. That was very useful. And to encourage the parties to vent some emotion, we call that sponging, and to listen actively. And that's when you're really trying to control the process without taking the dispute from the parties. So it can be quite brisk at the start, and then you've got the role of trying to keep it settled, but then allow the parties to operate in a way that works for them. Okay, so Jackie says, particularly when the parties are represented, can often be inflammatory. Do you find that lawyers in that sense, and I hope I'm not talking too much out of school, are not necessarily positive, Jackie?
So today I had a lawyer and a barrister against a lawyer, and sometimes they would just use inflammatory, so it's posturing, I guess, in some ways, really using inflammatory statements against each other, and I have to step in and try and calm the situation down and just remind them of why we're there. We're there for conciliation. We're trying to get an agreed outcome, and some of these statements they're making are not conducive to reaching a good outcome.
Yes. No, thank you very much. And certainly when I've acted for parties in a mediation or conciliation conference, you can either be, sometimes as a lawyer, you can be the good guy or it can be the bad guy. And I remember on one occasion, I hope this isn't saying things out of school too much, but the mediator said, let's have a break for a moment, and said to me quietly something to the effect, just watch it. You're being very aggressive, which is fine, but just watch it. He'll hit you. And I said, "You kidding?" He said, "No, literally, he'll hit you." So we just had to go back in, and I was still determined, but not quite as pointed as it was, as I was. So, and that's me, and I'm very placid normally, but it can be with lawyers. It can be a challenge. Personally, I prefer to have lawyers involved in any mediation or conciliation session. I think it does help. All right. Now, is there ever, Darcy says, is there ever an opportunity for a delegate organisation to attend in support, or will an employee always be represented by an industrial officer or solicitor?
Look, there's no hard and fast rule. Quite often I deal with unrepresented parties. They can have support people, they can basically have anyone they like. At conciliation, they don't need to seek leave to appear, because I'm not there to make a decision. But most often there are represented parties.
All right, so good question. Thank you, Jackie. We appreciate your expertise in that regard. So in terms of talking about the tempo, silence is something that you might want to use. When do you think a mediator would want to use silence as a technique? I'll give you a hint. I'm using it right now.
Give people a chance to think, John, about any question that may have been posed by either side. The other thing I think that is golden about silence, and I work with youth, and sometimes when there's an argument and they won't talk to each other, we tend to stay silent until one of them speaks, because it becomes too uncomfortable if somebody doesn't speak, and eventually someone will if you give them the opportunity. The second thing I find with working with youth in that context is that it's a good time to observe people's body language, because that gives you a good indication as to what may happen shortly or how the negotiation may process up from that point on.
Okay, so thank you, Nicholas. Some excellent points there. So silence encourages people to think about things. Craig says that might be useful when an option is presented. It also is an opportunity for the parties to fill a void. People don't like a vacuum. They'll tend to fill that vacuum, in this case with their own voice. The side benefit of that is that you're encouraging the parties to retain ownership of the dispute. It's not a court case. They're not all centering around you. You want to encourage the parties to talk, particularly to each other. It also provides an opportunity for the parties to think about options to resolve the dispute. And silence can sometimes aid in brainstorming. We'll talk about brainstorming throughout this unit. So silence has a number of positive attributes. Jackie says also to diffuse if emotions have run high. Just let it settle for a bit. That's another great use of silence. And if you're doing it properly as the mediator or conciliator, you're allowing silence but still retaining control by not saying a word. And if you're not doing it well, you're going to lose control, and then you have to almost jump back in and sort of say, hey, listen, I'm still here, don't forget about me. So it's that balance there. To some degree, as a mediator conciliator, you need to be quite confident to employ silence as a technique, but it's highly effective. All the time, you're actively listening, and Nicholas raised a very good point, and that is you're watching the parties for their body language. So active listening, you are trying to take information, take minimal notes because you want to maintain eye contact. So having eye contact and being able to write without watching the paper is sometimes an art you want to fulfill. And you want to use non-verbal skills such as nodding your head and having open body language. On the video, I'll be watching for your non-verbal activity as well. So the work that you do off the ball, to use a football term, is just as important as the work that you do while you've got the ball in your hand. So you're nodding, you're accepting, you're using active voice. During this week, why don't you practice your active listening skills, your ability to use silence where appropriate, your observations of others and body language, and your ability to use your own body language to convey a message. I mean, if you're interested in someone, you will look at them and you might even sit forward a bit. Just a small thing. You'll use open body gestures, so you're not going to cross your arms and sit back in the seat and look away, because all of those things are the opposite of active listening and engagement. So just practice those things, because you'll need to demonstrate them during the course of your assessment piece. Now, I mentioned earlier sponging. Can anyone tell me what sponging is all about? What's sponging? When would you need to sponge? Yes, Jackie's onto it. So you're looking to diffuse emotions if they've run high, and you're absorbing the party's emotions. Better you than the other side. The other side might respond in a way that you don't want. So as a mediator or conciliator, you need to be prepared to take a few hits, so to speak. And we do that through sponging.
From what I was reading, John, the concept behind sponging seems to integrate quite well with the process of reframing too, because you're taking in information, you're sort of gathering that, you're acknowledging what's going on with them, you're trying to break it down, and then you're going to reframe the issue. So the two terms, sort of sponging and reframing, work really well together cohesively.
And if you've established a little bit of a rapport in the opening statement, you've identified that we're using first names, for example, if someone starts to run amok, what you've got to be careful to do is maintain control, keep everyone together, and work through the issue. One of the ways that I like to do it is this. I might use my hand gently, without saying anything, to encourage the party to look at me. So if they start to vent, and this is typically at the start of the process, if they start to vent their emotions, then I might show them that I'm there to absorb that emotion by just gently, and you can't, I'm not sure you can see my hand, but just gently asking them to direct it to me. And people will normally follow the hand, and then they'll see that I'm looking, and then they'll start to talk to you. So we don't necessarily at that highly emotional stage want them to speak to each other for fear that there'll be a blow up or retaliation. So I'll just let them go for a bit. And what you've got to be careful about doing is not jumping in too quickly, being judgmental, trying to generate options. Just let them go for a bit, I think, so that they can get it out of their system. At the same time, you're not just letting them talk. You are very carefully listening. You're looking for words. You might even be writing a few words down. At the same time, using one hand to gently guide the party to direct this emotional outburst towards you, you've got to be very mindful of the other party. And that might be using your other arm to gently provide some sort of reassuring motion of, it's okay, I've got this. Just let him go. Just let him talk to me. So using one arm to say, come to me, the other one to say, it's okay, we've got this under control. It's a bit of a technique that you've got to use. Now, you don't want to do this for too long. I mean, the whole session should not be a rant, but sometimes people just need to let it out, and that's the sponging. So you're trying to absorb the emotion. You're doing it through a lot of silence, but a lot of body language, active listening, and trying to make a connection. You've also, at the same time, got to ensure that you're not seen as supporting one party instead of the other. And you've got to be very mindful that the other party will say, you don't want them to say, all you're doing is listening to him or listening to her. So just let it go. Let them know, the other side know that you're aware of them. And you will put a limit on it. Sometimes you need to engage in the reframing or summarising exercises quickly at that stage. And generally, you try and give both parties equal opportunity to have their say. Sometimes the other party wants to intervene. During that sponging process, they want to say something, particularly emotive, and you just got to let them know that you're there, that they're important, and they'll have their say. Now, are there any questions, comments as a result of that? You don't have to agree with me. Anything? All right, so we get an idea of what sponging's all about. Okay, time is getting on. what I'm going to do is just start something that I will continue next week. And this is a presentation that I did for the Queensland Law Society. And I'm just going to share the screen. You should see the presentation I did was called Applied Skills in Mediation and Conciliation. And I'll just go through a few slides. I don't usually use slides, but I will on this occasion, and I'll continue it next week. So I said during the session, and as I'll say to you now, that the work on applied skills in mediation and conciliation is practical in nature, very much what we're doing now. And I encourage the use of constructing checklists, which I suspect you're all doing that. And what I'm talking about the process of planning and preparing and then implementing various strategies and techniques during mediation and conciliation processes. So this process, this seminar, was aimed at encouraging practitioners to prepare for a mediation or conciliation in an active manner, drawing upon some of the skills and techniques used by the ADR practitioners during the mediation so that the practitioners are aware of how the mediation practice should work and things that they can do to prepare for the mediation or conciliation and then better perform and better represent their clients during the course of the session itself. So, of course, always ethical duties should be paramount. The paramount duty is to the administration of justice, and that's Rule 3 of the Australian Solicitors' Conduct Rules. So in terms of applied skills, number one is understand the alternative dispute resolution options. So if you're a practitioner going into an ADR session or speaking with a client about the possible benefits of ADR, the first thing you've got to know are what are the alternatives. So you must know, for example, the difference between a mediation or conciliation. Otherwise, how can you properly advise them in relation to it? And if you look at the textbook, you'll remember that there are 14 identified types of ADR, and your job as a practitioner would be to know those options and be in a position to advise your client as to which is the best one. Give the client the ADR options, provide advice as to which you think might be the best way to go, and then understand the role of participants in an ADR proceeding. Everyone has a different role to play. And in order to understand the role, you need to understand the basic ADR procedures, which really we outline in our opening. Preparing for an ADR process actually takes work. So for a solicitor or barrister representing a client going into a session, I'm sure Jackie would agree with this, the better prepared they are, the more likely they are to be effective as advocates and assist their parties in their clients and the parties to come to a resolution. Then they need to understand how to participate appropriately in an ADR process, and there are some specific skills. So they're the 7 things that I run through during the course of this session. I'm sorry, 8, the specialty mediation and conciliation processes. So definitions, I'm sure we all know this, or you've got your own definition that you're writing. Mediation is a process assisted the parties to a dispute identify issues, discuss options, try to agree. The mediator does not advise or determine. Conciliation is very similar, but the conciliator may advise, or if empowered to do so, make directions, orders, but not determine the matter. So number 1, understanding the alternative dispute resolution options. As a practitioner, you may select from a wide range, and David Spencer identified the list of ADR options, which hopefully by now at least is familiar to you as a list. And I think it's page 3 of the text that you should look at, and then have some form of definition or working knowledge of each one of these. Essentially, there are 3 main types of ADR process. That which is facilitative, to assist the parties to identify the issues, generate options, consider alternatives and reach an agreement. Examples are mediation or facilitation. And then we have advisory, which is, in addition to the features of the facilitative model, to provide the participants with an appraisal regarding the facts or the law and possibly comment on likely outcome. Examples include conciliation, case appraisal or expert appraisal. Or determinative processes where the ADR practitioner evaluates the disputes, makes a decision, and may conduct a hearing and receive or call evidence. So expert determination, mini-trial or arbitration. So when I talk about ADR, when I talk about lawyers representing parties that go into an ADR session, I'm really identifying that the lawyer, in order to do his or her job, must know the options, know something about the options that are available before they can provide proper advice. Next week, we'll go into much more detail about what it is that the lawyer should actually do in terms of preparing for the session and then attending the session to assist their clients. But I think for the moment that might wrap up what we will do this evening. Thank you for your attendance. Are there any questions or comments?
Yes, I was just wondering, you're sponging, but I think during an ADR, people some of them may keep going off on a tangent. So you kind of like reining them in. And the other thing is, I was wondering how much of that should we do in our, we have to fake it in our assessment. Like, do we tell our partners, at this point, you're going to call me a few names, and then you're going to call the other party a few names, and talk about the history of what's happened before, which has no bearing on this case. And then the immediate, I'm going to step in and say, this is not, what we're going to talk about today. This is a separate matter to be, dealt with, something else. Are we supposed to do that? Like,
no, they're really good questions and good comments. So I'll just respond to a couple of things that you've said there. Firstly, in terms of sponging, you're right. People do want to go off on tangents, and this is the importance of having an agenda, particularly an agenda where the parties have agreed that this is the agenda. So whilst they may be highly emotive at the start and they may wish to get everything off their chest, so to speak, during the course of sponging, you've identified some matters. You then move into a much more civil discussion typically. And during those opening discussions, after the parties have made their opening statements, what you're trying to do is receive information for fact-finding, but at the same time building the agenda. And you want to create the agenda relatively quickly in the process, so that from then we have a clear agenda, which means that if parties want to go off on tangents, you bring them back to the agenda that they have agreed to from the outset. So that's one point. In terms of going on beyond that, you need to encourage the parties to talk to each other and generate the options and the ideas, but at the same time remain focused. I will release the slides. I don't think I've released them yet, is the other question. So thanks, Monique. B, does that answer your questions? Oh, and sorry, in terms of the assessment, I'll leave that for you. And that may reflect your personality. You might say to the people that you're working with, please don't put me on the spot. I just want this to be nice and civil and just go through the ropes. I just want to go through it step by step and be very orderly. Other people might say, bring it on. I don't mind. Be emotive. It'll give me a chance to showcase my skills. So be argumentative, don't swear. It's on, but, be argumentative and play the part. And some people really get into it. So if that's what you want, that's great. But I'll leave that for you to decide. There are no hard and fast rules. Sometimes people have to contend with a walkout, and walkouts are tough because you get a party that says, that's it, it's a waste of time, I'm walking out, I'm out of here. Then you have to work out what you do. So sometimes I've actually made coffee for people. I've said, okay, how about we do this? How about we do this? Before you go, you've already spent the money, and I know it's tough, but if Jim doesn't mind, Mary, what if I take you out? We'll make a coffee. I'll make a nice coffee. I'm a barista after all. And we'll just have a chat about it. And that is the sort of thing you might have to do. But anyway, I'll leave that for you to decide with your teammates or the people you're working with as to how far you want to go. I hope that answers your question, B. And Monique, I will look at putting these slides up, but I might do it later after I've done the presentation, if that's all right.
Yeah, I had a similar question to B, John, and I think from what I understood she was trying to get at is how much information do we need to give in the assignment? How much information do we need to give to the other two people that are holding the dispute for us to practice ADR on? How much do we give them? Like, do we give them a storyline? Do we give them background information? Like, how much do we need to give them? Or are we just going to say, this is a family law dispute, you're the mother, you're the father, and this is the issue at hand is over time with the children? Like, how far do we go down the line? I hope I was right in assessing that, Pete.
Totally, and you won't like this response, Nicholas, but it's totally up to you. I think I mentioned that you can fully script this if you like. If you really want to, you can write a script where every word for the 25 minutes is predetermined and people are just essentially reading through the script. I wouldn't encourage that, and I wouldn't expect that people will stick to it. In my experience, people will always throw things in, and that might be to help you, but it might also be because, well, this is what I want to say, so I'm going to say it anyway. And it's remarkable how people get into the storyline very quickly. So you can just have a few words if you like. You can say this is a dispute between company directors who disagree about the extent to which dividends should be paid and the profitability. And if you just say, okay, so you're a long-standing director, you've never been formally trained, but you know the ropes, you've come up through the company, you were a senior employee before you were appointed to the board, that's your personality. You, on the other hand, you're trained at the university recently, this is your first job on a board, and you've got desire to bring in new technologies, new ideas, etc. And there's a dispute about the extent of dividends. Now, that's just an example that I've straight off the top of my head, and it's remarkable how people will get into it. And they'll make things up. It's like almost that silence things. So there'll be all sorts of things come in. But I'll leave that for you to decide, Nicholas. I hope that doesn't put you off too much.
No, that doesn't put me off at all. I think that might have clarified it for a few other people, hopefully. I saw a few heads nodding before. The only other question I do have with all of these notes that we're writing, obviously we're going to write things and give them to the other party, and we're going to write notes for ourselves. Do you want a copy of all of this stuff we put together with the link to our video, or are you just asking for the link to the video at the end of the day?
No, what you do is you prepare a Word document. I think I put a word limit of 300 words. The word part of it is not accessible. But in that, all I really need you to do is tell me that it's a dispute in relation to employment law or neighbourhood dispute or whatever it is, that you're a mediator or a conciliator, and perhaps provide some background, but you don't need to go into too much detail. So you're welcome to. I'll happily accept it, but I'm not marking the written work. It's only the video, the work that I see on camera. In the Word document, you include your link so that I can see it. I can see the video. Does that make sense, Nicholas?
Yeah, perfectly clear for me, John.
Okay, very good. Thank you. So B said, how much backstory? time to have get a preliminary meeting with your group? Yes, so start working with your group now. Lisa says, I'll email my group members a rough scenario, how I want to play it out, including a few surprise questions. So it won't be a surprise for me, but it may look good. That's good. And you can toss in a few extra bits, but guarantee people will add things in. They will, I'm sure. In the past, previous assessments have gone quite well overall. I think mediators tend to speak a bit too quickly, don't necessarily take control of the process. And that might be in part because they're thinking, I've only got 25 minutes, so I need to get all these things out. Just try to resist that temptation of getting everything done. In 25 minutes, it's unlikely that you'll resolve this or arguably even get close. So just work towards it as best you can. I hope that answers your question there. Thank you, Lisa. All right, any other questions, comments, feedback? All good? Okay. All right, well, thank you for attending this evening. We'll see you next week. And any questions, comments, please, through you, crew. All the best. We'll see you next week.